Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Hello and good morning, everybody. My name is Lisa Stam. I'm one of the lawyers at SpringLaw, and joining me today is Ben Currie, one of our newer lawyers to the firm, but not new to the world of employment law. If you are one of our clients joining us, you already know that we focus on employment and contracts law in our virtual law firm in Ontario, based out of Ontario. Welcome to those of you that are new to our webinar. We're very glad that you could join us. Please feel free to ask any questions throughout the webinar. Ben and I are ready to go to answer whatever questions you may have on this complex issue of PIPs, and we'll try and answer it throughout the webinar rather than waiting to the very end. Feel free to download the handouts that are also in the platform functionality, or ask us afterwards. We'll be posting a recording of this webinar on our YouTube channel, and the handouts can be available there as well. Finally, if you'd like more information about our firm, please visit us on our website at springlaw.ca, where we have a variety of resources, including our award-winning blog posts, our free employee contract checklist, our monthly webinar subscription program, and our monthly newsletter for you to sign up for, as well as some innovative the DIY type of programs and products for employers. So please join us on our website to learn more about our firm. So today we're going to talk about performance improvement plans, and Ben and I will be co-presenting. Ben currently lives in Halifax and works for SpringLaw remotely from the Maritimes. And as a virtual paperless firm, he has been a terrific, seamless addition to our team to augment our regional employment law expertise. Okay, before we start, I'd like to acknowledge that we are on the traditional lands of many territories, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat people, and that this territory is now home to many diverse First Nations, Inuit, and Métis people. We are lawyers, so we have to do a disclaimer. It is how it goes. This is all legal information today, not legal advice. And of course, any presentation is not complete without some sort of disclaimer. Here is a more detailed one. We're giving you information today that is always going to be specific to your situation. Okay, or will be unique to your situation, and you should contact a lawyer to get the specifics. Okay, today we're going to talk about performance improvement plans. We're going to talk about when is a PIP needed, what are the essential elements of a PIP, what do you do with a PIP in a unionized workplace, that intersection between PIPs and human rights, and then we're going to talk about next steps and when the PIP is not working. Now, I think PIPs are really this area where HR and employment law really intersect. So we're going to sort of zip through the beginning part of this, the essential agreements, because ingredients, because a lot of our attendees are people in the HR world who know exactly how to write a fabulous PIP. And so we're going to slow down a bit, and Ben's going to really dig into the next steps. When a PIP is not working, what are the legal realities? You know, a good PIP is really a powerful piece of legal evidence. But an excellent PIP is an HR doc that actually helps your employees really improve and stay long term, so that you don't need that legal stuff. So, you know, when all goes well, you don't need a lawyer for your PIP, but that upfront version of the PIP really is a legal document that you're going to want to rely on. Okay, Ben, over to you.
So good morning, everyone. I'm happy to be here today. As Lisa mentioned, the first topic we're going to cover here is when a PIP is needed, and this will likely be familiar to much of the audience, but we'll just cover it as well anyway, just for some brief background. So a PIP is going to be helpful when you have an employee who's consistently underperforming based on the standards that's expected of them. Note that I say consistently there. If there's just a one-off error with performance, there's probably other measures like a simple conversation and not implementing a full-blown PIP for that employee. I'm also going to cover just very briefly when it may not be helpful, which might actually be more useful. If you have a lot more going on with an employee than mild performance concerns, say there's excessive absenteeism, human rights issues at play that Lisa will speak about shortly, or if the employee for some reason is intentionally underperforming, there's probably going to be another process that you follow, whether it's accommodation, discipline, just another more appropriate route. So not the best option in every situation, but we'll talk about when it's most appropriate today and what should be in it. So I will say as well, for newer employees, you may see them used a little bit more often, just because there may have been insufficient training, the person's just not clear on how to do things or what the accepted procedure is internally or who to go to. But you may also see it with more experienced employees if the role has changed significantly, if there's new tech that's being used, and those types of things.
Okay, so let's talk about the essential elements of a PIP. I should note that a PIP is also sometimes referred to as an IAP, an improvement assessment plan. So just we're all talking about the same thing here. Okay, there's a number of essential elements of a PIP that really, there's no strict formula of what a PIP should look like. It's a document that lays out, these different ingredients, but are going to be really specific to your workplace, to your industry, to the employee in question. So and some of these ingredients really are what will support the legal part of it at the end of the day. So identifying what is the purpose of the PIP. You'll want to talk about that this is to require immediate improvement. It's not to try and fire someone. It really is to try and help bring forth that immediate improvement. So identifying what the purpose is just a key piece to start with. Where is the employee's performance falling below the standard? So this is where you start to get granular and identify what are specific problems that are at play. And the more that you can tie to some sort of number or metric or benchmark, the better, because it's easier to measure where people are improving on the PIP down the road. So are there productivity issues? Is there time management that's impacting when others can get their part of the project done? Is there inappropriate workplace behavior? Is there poor teamwork and poor communication? Is there sloppy work? Listing examples are all part of what will help really make this a tangible improvement plan that they can lean on for understanding what the problems are. If it's super vague, then it's going to be really hard to rely on your PIP as a document that sets out what needs to be improved. Another ingredient is, what is the impact of this poor performance on the business? And this is where it can really tie into some legal issues. So the more that you can specify that nexus between the poor performance and why it's a problem for the company or the organization, the more you can pull it away from any sort of individual targeted allegations of harassment or discrimination. This really is a business issue in the organization. So are there customer complaints? Are there team complaints? Have there been a bunch of late deliveries? Is there employee morale issues? And this is not necessarily required to have specific details at this section, but it is helpful evidence to rely on down the road that you do have legitimate business reasons for this PIP. What is the expected standard that the employee has to hit? And this is, laying out what is the game plan over the next period of time. So do you want them to, deliver a certain number of sales or perform a certain number of calls? Do you want them to be copying you in on emails or copying the manager in on emails? Are you going to be meeting with them in recurring meetings to really to keep on track of this for this period of time? And then if you can tie to any specific numbers, it's just better to do that, or any metrics, because then again, it pulls it away from the sort of vague, this vague improvement that you're asking for. What is the expected standard? Is also the actual behavior and delivery itself. It's not just some of the housekeeping items around that. So that's this expected standard. I actually see this well fleshed out on most PIPs actually, and this is, I think, what HR is really good at being very specific to the performance itself. The source of that standard is where we start to intersect with the legal part of all this. If it's a specific term in a a commission plan or in the employment contract or in a policy. Tying it to that specific standard is very helpful. It allows us to know why they have to do this thing that we're requiring them to do. It pulls it tightly within the job description itself. If there's compensation that turns on this, it allows us to be able to draw that line between if you have to do 3,000 sales a month and you get X number of dollars. It just allows you to tie the required standard together with the performance itself. And then listing past discussions about performance is also part of this HR law progressive discipline piece, where you're listing out, if they have, I don't know, salespeople are always easy to pick on because that's such a specific number. So if they fail to do, the 10 sales calls a day that they're supposed to do, and you've talked to them 12 times about this, what are the dates? Was there an email? Did you have a town hall about this? Was there a new policy that was rolled out? And then you followed up with them and talked about it in a one-on-one, making sure that you identify when the employee has already had this issue put in front of them is important. Part of that is that you don't want, like Ben mentioned, you don't want PIPs to be used for a one-time error. It's a big process, and it's a waste of HR's time, frankly, if you jump straight to a PIP. It needs to be really part of a pattern of overall performance. That's the issue. And so setting out when you've already talked to them about this really helps elevate it up to, okay, look, I mean, this is not quite a last chance agreement like you have in the unionized environment, but it really is a key pillar of your progressive discipline process if you're looking to rely on it for that piece of it all. And then listing supports available to help employees achieve their performance target. And this is where I really think no PIP should ever be rolled out as that first step towards termination. What it is if the core purpose of a PIP really should be, here's an employee that we want to invest in and we want them to do well and we want them to succeed. And so listing supports that you may have for them, coaching, any additional training, are there procedural manuals that they should maybe review? Is there an explanation of the process itself that will help improve their performance overall? So these are some of the main ingredients. Many of it will be very familiar to HR people. One more slide on this, and then I'm going to turn it over to Ben. This is where we start to see a bit more of the legal corner of a PIP. So it's good to state on that PIP that this will be added to their personnel file so that there's no ambiguity about what this, where this is going to sit, what's it used for, and so that there's transparency about the weight of the PIP. This is especially important if you are dealing with, maybe you have an ambitious lower level manager somewhere that keeps putting people on a PIP. This can actually help protect the employee as well, that this is a bit more of a transparent thing, that HR is in the loop on this. A key piece that I tend to see, but a very key piece of a PIP is stating the timeline by which the performance must improve. And it's typically, somewhere between 30 to 90 days. Don't do a PIP for a week or two, because that's not enough runway to really let the person understand what has to be improved and to then execute the improvements. So usually it's 1 to 3 months as a good PIP runway. The consequences if the performance does not improve. State this in every PIP, and this is probably the key legal part of every PIP, really making sure that this is not just a suggestion document that they ought to maybe consider maybe following. This is a key plan that they sign off on, and so that last bullet has the acknowledgement of receipt and review, that they sign off, that they've read, you've met with them, virtual or in person, but if somebody has talked to them about this, explained it all, make sure that there's alliance on what the ingredients are, and that if they fail to improve, what's the consequence. And that's a pretty standard ingredient of all progressive discipline plans in general, is making sure there's a clear consequence. And the phrase that every lawyer will tell you to put in there is include something to the effect that The failure to improve as per the PIP will lead to disciplinary action up to and including termination of employment. And there's enough case law out there that speaks to the importance of being specific about that consequence. If the last thing you want is for an employee to say, well, I didn't know that this is going to lead to being fired. It feels very awkward. Most HR hate putting this sentence in because it just feels very harsh and heavy, but it is a key piece if you want to be able to rely on this as part of, if they are unable to improve, then being able to act on that. Just a quick note on that last bullet about acknowledging receipt and review of the PIP, or however you want to word that, but getting a signature that they've read it. They do not need to sign off that they agree with everything, or that they agree that the performance is terrible, or they're not. And so some employees will push back on signing. But if you ask them a bit more about why, almost always is because they don't want they don't agree. They don't agree that they are performing badly. But that's not the employee's decision or assessment on this. So they're simply agreeing that they received the PIP, they've read through the PIP, they've had a conversation about the PIP, they understand that there is this timeline and this deadline, basically. And so they ought to be able to sign off on that, because that's all pretty objective. Ben, did you have anything else you want to add about the essential elements by any chance?
No, I think that's a good coverage of it all. And just on the last point about agreeing with the PIP, I had a recent case where the employee actually disagreed and didn't sign, and the employer is very diligent, documenting all efforts, and it eventually resulted in a complaint to labor standards. And the officer said that that was irrelevant. The manager was entitled to assess performance and make that determination that the employee had not met it. So I think that's a good point to mention at the end here.
Okay. Yeah, and we'll talk a bit about what this all looks like in the unionized environment, which is very different than the non. This in particular is very different than the non-unionized. Okay, we've got a question/comment, which I appreciate. I've always felt another essential ingredient or element of a PIP is to document the question: is there any reason you are unable to meet the expectations outlined above? Please let us know. I like that. I really like that, because it allows for that conversation if we need some accommodation, but it also allows for conversation about, like, does that person's manager really suck? Is there not enough resources? Is your budget too lean? Is there actually a deadweight employee in that group that's impacting this person's performance, and they're just trying to cover for them? There could be all kinds of innocent reasons why they're actually being forced on this, and that could help with organizational improvement broader than this individual. So I like that. That's a great suggestion, Neil. Thank you. Okay, on that, let's move over to unionized workplaces, Ben.
Okay, so as Lisa mentioned briefly, it is a bit different in a unionized workplace. A PIP is really not meant to be a last chance agreement that you see in a unionized workplace where there's been misconduct by the employee. It's not quite just cause to terminate, so you do this last chance agreement. This is different. It's not as common, I will say, in a non-unionized workplace, and it's hard to give general advice to unionized employers because collective agreements can look very different depending on who the employer is and what's been negotiated for. So the starting point would be to check that collective agreement and consider, it's probably not going to talk about a PIP specifically in any of the articles, but see if it's generally prohibited or if there's some alternate course that's suggested if there are performance concerns. What I would have commonly done in the past managing in a unionized workplace would be a coaching session with the employee, whereas I may document the result of that discussion, but it's not a written document that goes on the employee's file. And that may even be effective if there has been a few issues with performance. The pushback you may get is the union may say, since this is generally a document that would go on the employee file, they may say it's akin to a written warning and take issue with it and say that the employer is essentially creating their own process to deal with any concerns around performance and discipline, and therefore violating the collective agreement. So I could see a lot of unions not loving it, but it would be important to have those discussions and involving the union in those discussions, especially if you're going to meet with the employee to talk about the fact that they're underperforming. There's also a concept called past practice, which unionized employers are probably familiar with, that says if you're doing something a certain way, even if it's different than what's in the collective agreement, and there's mutual agreement to that, and then the employer reverts and starts doing things differently, the union may say, whoa, that's not consistent with past practice. You have to give us proper notice before you start to do something different, and this is just too far removed from management rights that the employer might be able to use to justify that action. So just another concept we want to flag as the cautions if this is an approach that's being considered in your unionized workplace.
Yeah, and it still always comes back to, don't do a PIP if your only reason is that you want to fire someone. The PIP, the purpose of the PIP really should be to a genuine interest in trying to improve this employee. And I think, you know, particularly in that unionized workplace, there'll be slightly less pushback on these if that purpose is really clear and the genuineness of that purpose is right up front. But I've definitely had conversations with employer clients that are wanting to fire someone, and they're trying to use a PIP to get there to be able to fire with cause and without paying out anything. And I can tell you that's always a disaster if that's your main purpose. And we'll talk a bit more about that in a later section. Okay, PIPs and human rights. So there is a intersection here between PIPs and human rights in that if the PIP is really can be seen, if an employee can argue that the PIP is an individually targeted thing against this person, where there's a standard being set or there is a requirement, a performance requirement being set that is not required of other people, or other people are, you know, just having a different level of standard altogether, then you don't want this PIP to be further evidence of a discriminatory claim. So if an employee requires accommodation due to a protected ground, that employee cannot ignore, or the employer, sorry, cannot ignore the employee's limitations and impose the exact same performance standards if it's not reasonable in light of the accommodation. But let me just unpack that. When you are accommodating an employee, you are entitled to have the same level of standard of that job to be performed. But how you get there is what the accommodation is all about. So and so I don't want this sentence to confuse that. You as an employer, you're entitled to just have the job done, but maybe the employee needs more time or more resources, or if the employee has low vision, you need to pull in more resources that way. If there's mental health issues on the table, that is highly individualized, and you talk to them about what may be helpful. If it's a return to work situation, where they're coming in on a gradual return to work, then parts of their job they may not be able to do right away, and you're still bundling with others. I mean, there's the whole range of regular accommodation, and requiring someone to be on a PIP during an accommodation, that is often asking for a lot of trouble, and it's hard to do. There needs to be a lot of pre-existing factors around the performance issues. And I would be very nervous about putting someone on an accommodation, and then if they're failing to meet that, then putting them on the PIP. It's possible, and it does happen, and there are certainly circumstances where you need to do it, but that nexus is very high risk of the PIP being interpreted as a failure to accommodate, or imposing a higher standard, or discrimination in general. And so this is where there's no single answer here, and I hate to say it, but it depends, and then you should talk to a lawyer if you are going to have any intersection of someone who has any sort of protected ground that they've already raised, especially if there's a disability protected ground, and a PIP. Make sure that you're getting some legal advice on exactly how to go forth on that super carefully. Ben, anything else on human rights in the PIP? I mean, I want to make sure that we're spending a good amount of time on the legal consequences of all this, but there's probably more that you want to add to this.
Yeah, absolutely. I think it's a tricky area, and I always say to
Mhm.
clients that sometimes it's just the optics of how things appear, and they'll say, the fact that this person requires accommodation or their disability has nothing to do with their reasoning for wanting to discipline, wanting to terminate here. It's really their performance, and my response is I completely agree with you, but the timing and the optics of this look bad. So there's a good chance that, for example, a human rights officer is going to want to dig in when they see that it might be interfering with their accommodation, or it looks like even in part it's related to the protected ground, for example, of disability, and then you're into a situation where you're having to explain that to a human rights officer and potentially carrying a human rights claim through. So there's the practical side of it as well, even if you're saying internally, look, this has nothing to do with human rights. It's still a little tricky.
Yeah, because it is in the eye of the beholder, right? It's how the employee is reasonably perceiving the situation. And so another good example that's not a disability is if someone comes back from a longer parental leave. They haven't, if the workplace really changes quite a bit in 12, 18 months, and they're now coming back in, it could be that they actually need fresh training, even if they've been with you for a decade prior to that. And so it may not be that there's a performance issue. It's a knowledge or experience issue if things have really changed. And that's on the employer to make sure that their employee is properly trained, as opposed to it being a PIP itself. So, that's just another example of that intersection. Was there another question here, Ben, that we should be adding? When is it too late to implement a PIP? What if an employee is already subject to the progressive discipline process? Felicia, I'm going to pause on that because we're going to be talking about that in the next section. So let us get through the next section first, and then we'll come back to that question if it's not answered. Okay, Ben, next steps when the PIP is not working. What do we do?
Yeah, so as we mentioned, this is where we want to dig in a little bit more, because we're sure that a lot of you will understand when a PIP may be needed and what those elements are, and then you kind of get a bit of a template together and how to use it going forward. But this is where we often get pulled in, especially when it seems to not be working, and the question is, where do we go from here? And there's several options, but really the first question that we will always have is, where are we at on the timeline and how much time has passed? So as a starting point, what's the date the PIP was implemented? And that's usually pretty easy to tell by looking at the document. But the follow-up questions from myself would typically be, what's happened since then? Like, even if we are past that, 1 to 3 months that Lisa mentioned as a timeline for an initial PIP, what's been happening? Has the performance improved at all? Slightly, not at all in all of the, ideally objective areas that you've listed in that PIP? And what's happened? Has the person met with the employee to talk about it? Normally, we would recommend regular check-ins just throughout the course of that 1 to 3 months, just to see, are these standards clear? How are things going? Is there any further supports you need, whether it's training? I appreciate this sounds a little bit onerous, but we're talking more about best practices and things that should be considered. So it's not necessarily meeting with them, 2 or 3 times a week, but there should be at least a few check-ins, especially if you're planning on later relying on this. So those are the types of things we'll figure out, and really the answers to those questions are what dictate where we go from there. Especially if you're on the shorter end of a 30 to 60 day PIP. I think of a client in retail sales, and their standard is usually 60 days. And especially if there's minor improvement in some areas, but clearly still not quite reaching it to the point where the PIP can be discontinued and they would consider it to be not working, you might consider an extension. And generally that would follow a similar format to the original PIP, but you may change the language a bit more, because you're going to want to say, this is how your performance has been since, January 1, for example, when the PIP started. We're still not quite there in these areas, and you really need to be to do this job. We're going to give you, another 30 or 60 days. But then you may strengthen the language a little bit and say, not as theoretical about whether there might be discipline, but maybe at this point you say, it's likely, or we will terminate for cause, for example. Maybe a little strong depending on the situation, but just to say that you do want to modify the language and not just give them the exact same document again, to acknowledge that there has or hasn't been some progress, and acknowledge that, look, we have met with you, we haven't understood that there's been any concerns or that there's any further supports needed, but we would like to give you this additional opportunity to show us that you can improve, and hopefully we can get there. Because as we mentioned, the idea is not that this is just a tee up for termination. The goal is really that this can help the person move on and ideally get there, so we're not into that conversation. Leading into the next slide though, there may be situations where you go through these extensions, there's really not a reasonable explanation, whether human rights or lack of clarity as to why the person's not improving. And then you're into a discussion that, can we fire this person? Can we terminate their employment because we've given them every opportunity, we've done everything we can, we've extended it, it's just not working out, and we're just not getting there. So the general answer is yes, and of course, as we always make our joke, it does depend on the situation. So it is important that you follow the steps that we've talked about in terms of the essential elements that Lisa covered, and that they've been given a reasonable timeline to show that they can improve. An important thing to consider though is that if you're at that point and you're considering termination, there's always the question as to whether you want to call it a for-cause termination or not. And you'll see at the bottom there, we have linked one of our prior webinars where we've dug into this a bit more because it's a big topic. But just generally in Ontario, there are two standards for cause to terminate. There's the willful misconduct standard that you'll see here. And the court's been very clear that because that requires intent, if someone's trying and not improving on a PIP, that's never going to meet that higher standard, which means you can terminate them without providing that minimum notice in the Employment Standards Act. And the idea really is, unless they're intentionally underperforming, which would be a bit of an odd scenario, it's just never going to meet that standard. So really our question is, does it meet the just cause standard at common law? And it is possible, but even then, an adjudicator or a judge is going to really look for all of these things we talked about and say, look, were they clear about this? Were the timelines reasonable? Did they actually try to help this person? And it's really the court saying, like, does this just look like a quick tee up determination, or do the employer really go through the proper steps here and try to help this person and, check in with them regularly, have reasonable standards? Another thing I look for as well is especially if I see the numbers that, don't quite line up, if there's an extension, I'll say, are these the standards everyone is held to, or is this a higher sales standard because you're looking for this employee to kind of make up for past failures? Because consistency is very important as well. And that's why we say it's great if those standards come from a document like a policy or a commission plan. And, we appreciate it's a little bit easier in the sales context. But we just flag that because we would recommend especially that you talk to us and get some advice before you take the step of wanting to terminate while someone's on a PIP. And I'll just hand it over to Lisa briefly if anything further to add on that.
No, I think you covered that really well. I mean, I think most employers are, it is definitely part of the consideration, right? If rather than moving to a termination, they want to try and improve this person. So there's that fork in the road to decide which way to go. And I always encourage the employer, if there's absolutely no hope that this person will improve or meet the standards required, or it's just absolutely not the right skill set. I hate the word fit, but if they're the wrong skill set for the role and the job, just fire them, give them a good package, and we all move on. Yank that Band-Aid off. Making someone suffer through a PIP only with the known intention that you shall fire them at 90 days instead of now because you feel bad, or you don't want to have that difficult conversation, or you want to prove to them that they're not the right fit for your workplace. Don't do any of that stuff. Either fire them because they're not working out, but give them a fair package, or if it's a genuine hope that they can improve, then go forth on that PIP path. But those two concepts, we have those conversations all the time with employers about, a PIP is a lot of time and effort, right? So just don't do it if you think that it's your shortcut. But you know what? I think that's what you're going to cover on this slide. So I should have not taken over your first bullet there. So why don't we move on to this slide?
Yeah, so it's a good lead in for sure, that it's really not a shortcut. Sometimes we might just have that conversation, and as Lisa mentioned, a without cause termination may be just more practical, and it kind of ties into that previous webinar we talked about termination clauses. So you can control what those entitlements might be for the employee in that situation, and that just might save everyone's time and actually save money at the end of the day, since it's going to take a lot of time for a supervisor and or manager and HR internally to follow this process through till the end, especially if you're trying to do a for-cause termination, which is tricky. We also know just practically that terminating employment and then having to recruit a new person for the role is very costly. So it really goes back to that the actual goal of this is that this employee will improve. I don't think any employer starts, and unless there are other things happening with this employee, in which case I mentioned at the start, there may be other avenues that are more appropriate. But really, we want to help the employee improve and avoid those costs. Generally, you've hired this person for a reason, and it may just be, as I mentioned, that there's a simple miscommunication in, procedures, what the standards are, how they're to be performed. Employees may not understand the supports in place. And Lisa mentioned previously as well that roles change, especially if someone's coming back after a lengthy leave. So if all that's needed is a refresher, it's much easier than paying someone out and having to start from square one and recruit a brand new employee and bring them up to speed. And then, who knows, you may be in that same situation with the new person. So a lot of costs that are just, easier to avoid there from a business perspective as well. And just on the final point, which we've already covered, it's great if you have a good termination clause, because it makes that decision from a cost perspective just much easier, that you might just want to terminate without cause. Even if you do feel like you have the elements to terminate for cause, it's just more likely to invite a lawsuit that, from the perspective of the employee, they've been given nothing, and it might impact their ability to seek EI and move on to a new employer. Just a lot of issues that it creates on their end, and then that creates additional headaches for the employer as well. So on a practical level, we may often recommend a termination without cause, just as a more easy way forward for both sides.
I agree, especially if it's a less expensive termination. Maybe a more frontline employee, shorter term, younger, or in an industry where it's mostly ESA only type terminations anyways. Then do the math around the cost of a PIP, and the time and resources and pulling in your team to do it. It might just be the best math to just terminate without cause, give a package, and move on. We have a couple of questions, and I encourage everyone to keep throwing them in. When is it too late to implement a PIP? What if an employee is already subject to the progressive discipline process? This is one that came in earlier, so let's dig into that now. So when is it too late to implement a PIP? Do you have any thoughts on that, Ben?
Yeah, I think it just goes back to the amount of time that, and the reason for what's happening in the first place. Like, my immediate thought is, and obviously I don't know the specific facts behind this question, but if someone's been subject to progressive discipline, it may be for reasons beyond just performance. So you really need to ask yourself, like, does it make sense for us to now revert, and instead of continuing with progressive discipline, which would, if it continues, ultimately go toward, for example, a written warning, potentially to a termination, does it really make sense to go back and say, wait a second, maybe this is really just a misunderstanding of performance, so now I think we're going to go back and do a PIP instead? And it's just remembering the reasoning for why you do them in the first place, and that they're not intended right off the beginning to be disciplinary. So it may just be stopping at the beginning, and I appreciate we're at a different timeline in this question, and asking what's actually happening here, and do we want to go the route of a PIP versus progressive discipline? Because now that we've gone progressive discipline, it's a bit of work to backtrack. It may not be the easiest or best course of action, depending on what else is going on in that scenario.
I agree, and I think that goes back to the purpose in the first place, right? So if this is someone who is being fairly deliberate about their misconduct, or unapologetic about it, or defiant about it, or like if they're chronically absent with no good reason, or chronically late for no good reason and defiant about it, and you've already done a bunch of warnings, I don't know if a PIP is really, and I think it's because some people do conflate the idea of a PIP being like a last chance agreement, and it's not. A PIP is very different in concept than a last chance agreement. So maybe it's in those situations. So I agree with you, Ben. I think at some point it is too late. When, I don't know, that very fact specific for sure, but it's when the purpose gets too conflated between the progressive discipline stage. Let me just, go ahead.
I can jump on the next question if
Okay,
there's.
great, thanks.
I see there's just a question. It kind of ties into the topic that I finished on, but I will address it just in case there's still some lack of clarity there. But unclear about if a person goes through a PIP and it's not working out, that we can still do a without cause termination, or is it for cause at that point? So I'll speak about that a little bit more so it's clear. Really, a without cause termination you can do at any time in the employment relationship, assuming it's for non-discriminatory reasons, you're not attracting a human rights claim. The idea would be that assuming you follow all the steps that we've discussed today in terms of all the essential elements and the timelines, et cetera, generally that should be considered enough for a just cause termination. I talked a little bit about the different standards. So, but really, like we said, practically, because it's even such a high standard to meet just cause when it's performance issues, like I've seen the courts in decisions where someone's terminated for just cause say it needs to be, grossly underperforming, or just using adjectives that make it a very high standard. Sometimes we say, look, you may have cause here. We appreciate you've done everything right, but what's this person entitled to? Can we just do a without cause termination? Because at the end of the day, for the reasons we mentioned, it might just be more practical, even if you feel like you do have cause, just to avoid the cost of litigation that might ensue, and avoiding that additional headache to just kind of deal with it on a quicker and less costly basis in the end. If that, hopefully that answers a bit more there.
Yeah, and it's a good tie into Manisha's question here. Are there any legal obligations if an employee on a PIP is fired after the completion without cause, with proper notice and compensation? So this, I think, is related to what you were just saying, Ben. It is a very fact-specific situation. So if a person's on a PIP, I don't know, because they've been doing all kinds of financial impropriety and they've been warned to stop doing, I don't know, false expense claims, and then they steal money, then you can just fire for cause at some point and not worry about it. If it's, I'm trying to think of it, the extreme. As soon as someone is stealing money and lying about it, then usually you can, that's going to be in the realm of for cause often. If it's on the other end of the spectrum of sort of fireable offenses, if there's someone who's just, they're often late, for example, by 10 minutes, and it's annoying, but and you've warned them, and so yes, it's insubordination if they continue to do it. But is it really a just cause termination? I think it's going to be hard to meet that threshold, even in the context of a performance management system. It'll be hard if it's just chronically late. Not impossible, for sure, and especially if there's some consequence. If it's a daycare and kids are sitting there by themselves, obviously that's a different story. If it's a remote office worker and it just doesn't matter when they show up, then so it's always very fact specific. So are there legal obligations if you go along the PIP, they fail to meet all the metrics, and then do you need to what are the legal obligations there? And unless, talk to a lawyer, but unless it's really truly a for cause facts situation and situation in general, then your legal obligation is still going to be a without cause termination. So all the usual, either employment standards minimums or common law if you don't have a contract, or a contract if it's enforceable. Again, a PIP is not the step to termination. A PIP is a step to improvement. And so it doesn't eliminate many termination packages. It just is the path towards hoping that they don't need to be fired. Anything to add to that, Ben?
Yeah, no, I think that covers it good. I see there's another question here just for any suggestions about making the case to implement a PIP in a workplace where they've never been used before. So definitely if it's unionized, I'd remind the employer of the concerns there about whether it's engaging the collective agreement, and that kind of goes to the past practice concern. Assuming it's non-union, there's definitely a lot more leeway for an employer to do something like this, especially where the whole idea up front is that it's not disciplinary. The more important thing would not be that you're restricted in implementing it up front in a non-unionized environment, but that you do it the right way, following the elements and all the considerations we mentioned, especially if it's something that you're later needing to rely on if things go south.
Yeah, and I would say it's not like you're rolling out a brand new policy about how people have to do their job. You are simply rolling out a vehicle to help somebody do their existing job. So, Felicia had a good question here about if there's no formal policy, so it's related to this. If there's no policy in place about being able to do PIPs, again, Ben's rightly flagging the unionized workplace issue where there's just pre-existing rules that you've all bargained for already. But in this case, if you don't need a formal policy saying in the event that there's no, that there's insufficient performance, that we reserve the right to roll out a PIP. And I know that in so many other areas of employment law, reserving that right to the employer is really important, but I wouldn't say that that's the case for a PIP. The PIP is really meant to be more of a good faith, good gesture. Again, assuming that the purpose is aligned with what you're doing and how you're doing it. I don't think you need any sort of pre-existing policy. And if you haven't done it before, just do it. Just do it with all the right purposes in mind, and conversations and meetings, and make sure that it's all transparent and reasonable. Any other questions here?
I'm seeing one here about when can you terminate and pay ESA only. I'll start to answer that. It's a bit of a loaded question, but I can certainly start to answer that. The first answer would be if you have an employment contract for this employee that limits them to the ESA, that would be, and validly does so, which is, challenging in Ontario, just given recent decisions. And, we've covered that in other webinars as well. It's a big topic, but assuming that's the case, then you can terminate without cause and pay ESA only if you have an enforceable contract that says you can do so. The other situation kind of goes back to the two standards we mentioned, where there's this higher willful misconduct standard to meet. And if you don't meet that, which you never will for performance reasons only, you will have to pay that ESA amount, even if you have just cause at common law. That's really a loaded answer that it would take quite a while to flush out, likely, but those are kind of, in summary form, the situations where that would be the case. And I'll just let Lisa maybe add to that if there's any clarification that we can provide on that.
No, I mean, you at the end of the day, you still have to pay close attention to what's in their contract. And so what is their contractual right? And so if their contractual right is that you already have it nicely set out in an enforceable contract that says ESA only or statutory minimums only, then a PIP doesn't change that. So it really does come back to that contract. And like you said, Ben, the contracts are all getting set aside. These termination provisions are being challenged all over the place. And so if your contract is more than 3, 4, 5 years old, there's a good chance that the termination provision itself may not even be enforceable. And so you would be looking at a common law package one way or the other. So then the big question is, can the PIP help contain that big picture exposure? And I will often say to clients, if you're going to fire someone, it's like being pregnant. You're either pregnant or not pregnant. There's nothing in between. So it's either for cause or without cause. And so you don't get to discount or it's in the same way that if a company is financially distressed, you don't get to pass that burden on to your employee at law. There's this standalone termination entitlement that employees have one way or the other if it's a without cause termination. The thing that a PIP can do, though, it's a creature of negotiation. So if at the end of the day the employee really is not performing well, and it's so close to cause, you could allege cause and sort of take the risk that they may or may not fight. And if they fight, know that at some point you can still settle out. But you might be looking at a claim as well. So I think often PIPs, if it ends up being this on the line, cause, not cause kind of situation, employers will take some creative approaches to firing with cause, but being very ready to go on a without prejudice settlement agreement. So, and that's a whole two-step letter process that we will often advise on. That's pretty complicated, so I won't go into details here. But if it's on the line, sometimes there's a bit of a creative approach, but you're not going to be able to not pay termination pay unless it truly is for cause. And we all know it rarely is in Canada. If an employee decides not to sign the PIP, is it still enforceable? Yes, it is, because all they're signing off on is that they acknowledge that they have, that they have received the PIP. They're not agreeing to the PIP. That is a management right, to use some unionized language, but that's the company's prerogative, right, to run the workplace. And if somebody's not doing well, and again, if the PIP is being set up as a genuine effort to help somebody, it doesn't matter if they sign off or not. You can still enforce it, but it's very, very important that they're very aware of it. So if they refuse to sign off because they just don't believe you that this is only an acknowledgement of receipt, and they don't sign off, you will still want to figure out a way to have some evidence to show that they received it, right? So whether it's an exchange of emails to say, further to our conversation this morning, here is a copy of the PIP that, I also gave to you in the meeting this morning. Something to just make it clear that they have it in their hands, so that they can't deny the existence of the PIP down the road.
Yeah, absolutely. Yeah, and even with those check-in meetings, like it's good to have record of it. Like I'm just thinking of a situation where the employer was very good to document things themselves, but also to send emails to the employee, just like Lisa mentioned. Further to our meeting this morning, here's a summary of the expectations, and for more detail, please see the PIP attached, which we were provided with earlier. And then same thing for a check-in meeting. Further to our follow-up this afternoon, we're still concerned about these areas. We're going to be monitoring these closely. We're going to extend the PIP, et cetera, and really having that paper record to the point where an adjudicator is going to say, yeah, maybe you didn't sign it, but the employer wasn't required to get your approval to do a PIP, and clearly from this evidence, you were aware of it and reminded of it throughout. So that can help deal with that concern, because we do realize that that can be a reality.
If you're trying to impose new or additional standards on an employee's job, then that's where you're going to get into trouble. But you always have the employer right to require someone to do their job description, right? As long as there's a lot of clarity and agreement and transparency about what is on that job description. So again, don't use a PIP to add on a bunch of stuff that they're now failing to do. It needs to be this transparent process of helping them to improve on their existing job. That's the narrow purpose of a PIP.
Yeah, that's a good. I was just going to say that ties back to our question earlier about if we haven't done a PIP before, can we do one now? And Lisa's comment earlier that the more you can tie back to existing performance metrics that are in an employment contract or a policy or a commission plan, yeah, the process that you were doing the PIP may be new, but we're really just enforcing what was already expected of you per these documents. So that kind of helps alleviate that concern as well, I think.
Okay, I think we've gone through the questions, unless am I missing any here? We are through these, so why don't I move on to our takeaways. If anyone has any last minute questions, for sure to send them through. We still have a bit of time, we can certainly answer them. But as our key takeaways for today, seek counsel when developing a PIP. And I don't say that often. I don't like when lawyers are always trying to like upsell our services. That's not what this is. I just think that PIPs are, a big chunk of PIPs are pure HR, but there's that corner of it that is a very key legal piece of evidence to rely on, especially when it intersects with human rights or if it intersects with terminations. Those are legal moments. So, for many situations, we do think you should get some counsel on developing the PIP. It's critical that the performance standards are consistent and objectively reasonable. Again, we've talked about don't add stuff on, don't make it this catch-up game for them. Don't make it a penalty for failing to do what they were supposed to do last year, and now you're gonna, punish them and test them to see if they've got resilience to fight and work in your workplace. Don't do any of that BS. It's just, can they improve on their existing job description? That's what you're after. You have to provide the employee with the tools to improve. So make sure that in order for them to succeed in this PIP, if they need more resources, more training, some additional management, some more mentoring, whatever it might be, some technology, make sure that they have those tools to improve, so that you're always trying to set the employee up for success as part of that good faith background to all of this. And then give them enough time, right? Adjudicators will expect employers to provide a reasonable opportunity to improve, even, or especially, not even, especially if you want to terminate for a cause after, and, you know, consider the costs involved. It is expensive. Turnover is expensive. It's hard on employee morale, the recruiting, the training, the runway, to get someone up to speed is hard. If you can improve an existing employee, that often is mathematically better. So, you know, keeping that in mind, but you need to give people a fair runway. It's not a thing that's going to happen overnight. Any other big picture takeaways, Ben, especially in light of some of the questions that came through?
Yeah, no, they're all great questions, and I think it's a good summary just on, you know, some of the most key points that we mentioned. But I think the timeline is huge. I know a lot of times when, you know, going back to my discussion about when it's not working, I think a lot of times when I talk to employers, when they're in it and in that workplace every day, 2 weeks can feel like a year if someone's, you know, not quite getting there. But it always goes back to, you know, are we jumping the gun here? Have they had a reasonable timeline? This is what's going to be expected if you're looking to rely on this later should things not improve. So I think that's really key, is that, you know, sometimes just getting that outside perspective on if it's been long enough, and those additional questions about have they improved at all, because there's just so many different scenarios, and, you know, they're never the same twice. So sometimes it's good just to get that second opinion, whether it's us or someone internal, on what's actually happening, and have we waited long enough, or is there more that we should be doing?
It's such a good point that when, you know, when we talk to our clients, when they're in the heart of it all, every day feels like a billion years, right? And so when we suggest 90 days, like sometimes their heads explode a bit, because like, do they really have to wait another 3 months to deal with this? But that goes back to, if you just need to fire this person today, then do it. Give them a reasonable package. But and sometimes it's a relief for everybody. Sometimes they're waiting for their package, you know, and or they, you know, will be happier somewhere else. I mean, terminations are sometimes a win-win for people. Not always. I know that they're hard on employees, but this lingering of people is way worse. And there's case law on how you shouldn't be doing that. You know, that can lead to some bad faith damages if you just sort of like hope that the employee will quit on their own volition because, you know, you've made the place sufficiently uncomfortable for them. So PIPs should be for a reasonable period of time with a good faith purpose to improve, not to terminate. Okay, I think that concludes our webinar for today. Thank you very much, everybody, for the good questions. Our next webinar is going to be on December 19, also at 10:30 in the morning. We do it the third Wednesday of every month morning. We're going to do a 2003 wrap-up of key case law and developments for the year, to sort of get everyone all up to speed and ready to go for 2024, which I can't believe that's just around the corner. If you have any questions, please feel free to follow up with either Ben or I. If you'd like more information, again, come to our website, follow us on all of our social channels, our Facebook, Twitter, LinkedIn, Instagram, TikTok, all those things. We will be posting this video on our YouTube channel, and we have many other webinars that you can take a look at if that would be useful to you. Our monthly newsletter, feel free to sign up for that. And then you'll get just the collection of our weekly blogs to you so that you can really stay up on the law. I think that's all for today. Ben, thank you for all your wisdom. You had a very big hand in putting this webinar together. Thank you very much. And we will see everybody next month.
Thanks, everyone.